All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Sean Quinn presiding.
Be seated, everyone. Good afternoon. Again, my name is Sean Quinn. I'm a judge with the Workers' Compensation Court of Appeals. Today's date is November 3, 2025. We have one case scheduled for oral argument, Bjornson versus McNeilus, which has two file numbers, WC 236530 and WC 256601. In addition to myself, our panel today is made up of Judge Sundquist to my right and Judge Christensen to my left. Today's argument is being live streamed and recorded. More importantly, today's argument is part of our court's effort to bring real-life workers' compensation to law schools, specifically the University of Minnesota Law School today. And I want to thank the law school and their staff, particularly Diana Witt, the experiential education program manager, for making this happen. I'd also like to thank both lawyers, Mr. Wolf and Mr. Klayman, for taking their time to arrange their schedule outside of our normal courtroom situation. In fact, for Mr. Wolf, I'll thank him doubly. He was here for oral argument at this very law school at about this very date a year ago for our first oral argument at any law school. So anyway, for both counsel and for the benefit of the recording and live streaming and our in-person audience, we would ask when presenting your argument, speak loudly and clearly and into the mic. I also will remind you of our timing rules. You each have 15 minutes total for your respective arguments. We'll give each attorney 3 minutes of uninterrupted time to start. Once those 3 minutes are up, I'll stop you and ask members of the panel if they have any questions. As to the total of 15 minutes, the burden is on both of you to keep track of your time. Normally we have a clock with a dais and lights and all that. Today we have our marshal over here, and she will have cards holding up with 5 minutes, 2 minutes, and when time is expired. So pay attention to her. You may, for the appellant, you may reserve as much or a little of the 15 minutes as you wish. You don't have to tell us how much you're reserving. Just keep track of your time, and the marshal will keep track of what you have remaining. When you step up to the podium, identify yourself and the party you represent. Mr. Klayman, I think you're probably the appellant for both of these cases, so we will let you proceed first.
Excuse me. May it please the court. My name is David Klayman, and I'm here on behalf of McNeilus Companies and its workers' compensation carriers, Travelers Indemnity Company of America, and Property Casualty Insurance Company of Hartford, the appellants in this case. Now, we're here in law school, and I'd like to reminisce about when I was in law school, and we all learned that if the facts are on your side, argue the facts. If the law is on your side, argue the law. If neither is on your side, make the case as complicated as you possibly can. Now, I think the case is very simple, and I'm trying not to complicate it. I also think the law and the facts are on our side. The issue before the court is simple. Does substantial evidence exist to support Judge Pearson's determination that Attorney Wolf recovered an ascertainable amount of attorney's fees on behalf of his client? The answer is quite simply no. There's no evidence in the record to support that determination. Therefore, this court should affirm its decision on March 11, 2024 in its entirety. As this court is aware, the Minnesota Supreme Court remanded this case to the WCCA with the instruction that you should remand it to Judge Pearson again. And you were instructed to remand it to Judge Pearson so she could answer one simple question. Whether the itemized bills from the Mayo Clinic were the actual itemized bills or Exhibit G, the summary document of the voluminous medical records prepared by counsel. Now, on remand to Judge Pearson, she acknowledged that Exhibit D, submitted on June 5, 2023, only included the employee's claim petition form and the employee's itemization of benefits claimed, a total of 8 pages. It did not include the bills and records from the Mayo Clinic. In finding 8, she stated, Exhibit G was simply a summary document of the medical records. Now, Exhibit G was actually an itemization of Mr. Bjornson's claims, not the medical records. That's not important for the issues today. There were no bills or payment records attached to that exhibit. In short then, the medical bills from the Mayo Clinic were not submitted into evidence at the attorney fee hearing of June 5, 2023. That should have ended Judge Pearson's involvement in this case. She could have issued a one-page decision and simply said the medical bills and records were not in evidence. However, she attempted to explain her reasoning. It's our position that her reasoning was misguided. In multiple findings, Judge Pearson referenced the claim petition that Mr. Wolf filed on Mr. Bjornson's behalf in March 2022. In her findings and order on remand, Judge Pearson indicates that that claim petition included the records and bills.
All right, Mr. Clayman, I'm sorry I'm going to interrupt you now. Questions from the panel?
Mr. Clayman, I'd like you to continue to tell us what that claim petition what was attached to that claim petition, and also why it was important, at least in your argument, that that claim petition, along with all of the pleadings in this case, was dismissed with the award and stipulation.
Your Honor, I'm not certain what was attached to that claim petition because it wasn't in evidence. And I will say that that claim petition was dismissed. It was dismissed without an adjudication on the merits. The Supreme Court has held that if a claim petition is dismissed without an adjudication on the merits, it's as if it was never filed. And if it's never filed, it's our position one cannot rely on that claim petition and its attachments as evidence. It's not in the evidentiary record. Again, it's as if it was withdrawn. One can't rely on a withdrawn claim petition any more than one can rely on a claim petition that is dismissed without an adjudication on the merits.
Well, I'm not going to argue Mr. Wolf's case for him. He'll do a fine job himself, but as I understand it, he's going to say, at least in part, but you do know what was attached to the claim petition because you, David Clayman, got a copy of that claim petition with all the attachments, so you know and your client therefore knows. So isn't that enough?
No, Your Honor, that's not enough. And the reason why it's not enough is just because something is filed, if it is subsequently dismissed, it's as if it was never filed. If we are going to rely on everything that is filed and withdrawn or filed and dismissed as evidence, it will be impossible for an attorney to know what evidence a judge will rely on in reaching his or her decision. That claim petition does not exist for the purposes of the law. It was never filed. It doesn't exist. That's the DeMars case from the Minnesota Supreme Court.
But Mr. Clayman, assuming that the Supreme Court says that can go in as part of the record, and that's part of the record that we have to evaluate under our standard review, would that information, the 143 pages that were not included at the attorney fee hearing, if you had that before you, how would you have presented your case differently? And would that information within the 143 pages be enough to qualify as ascertainable medical bills?
That's an interesting question, Your Honor, and I still think the answer is no. And the reason why is in the Irwin case, the Minnesota Supreme Court said, it doesn't matter what was billed. It matters what the fee scheduled amount of the bills are. Fees aren't based on the amount billed, the amount paid. It's based on the fee scheduled amount. Nothing in those bills shows a fee scheduled amount. Nothing in those bills even shows exactly what was paid.
And my question is anywhere in the record, the exhibits introduced at hearing, subsequent reviewed by Judge Pearson the second go round, do we have that fee schedule amount anywhere?
No. We have an amount that Mr. Wolf claims was paid, and it's never indicated that it's subject to the fee schedule.
What about his testimony?
Well, his testimony is interesting because, again, in his testimony, he doesn't say it's a fee scheduled amount. And no offense to Mr. Wolf, but I don't think one can rely on his testimony as support for the amount of the medical bills paid, and here's why. In our brief to this court, when it was first on appeal, we cited the Moore versus University of Minnesota case. Moore, M-O-O-R-E, 5 simple letters. I goofed it up. I spelled Moore, M-O-R-R-E. It wasn't until this case was at the Supreme Court and back before this court that I got Moore right. 5 letters, I messed up 20% of them. In his initial brief to this court, Mr. Wolf cited the exhibits. He did so incorrectly. He introduced 12 exhibits into evidence, 12. On page 3 of his brief to this court, he identified the employee's claim petition as Exhibit F. That's not Exhibit F. That's our answer to the employee's claim petition. The employee's claim petition was actually Exhibit D. On page 13 of his brief, he identified the award on stipulation as Exhibit H. However, the award on stipulation was Exhibit I. We know he made that mistake because there's evidence of what the exhibits were. Here, there's no evidence of what the bills were, of the amount recovered, of how the math was done, of any of it. All we know is that in Moore, I was off by 20%, and in identifying the exhibits, he was off by more than 15%. So without exhibits that we can point to and substantiate the math and the calculations and what was paid, I don't think we can rely on testimony alone to establish an ascertainable amount of recovered bills.
But Mr. Wolf, in his brief, the current brief, says something, and I'm paraphrasing, but something along the lines of, I testified to a number, claimant didn't do anything to dispute that number. Now it is, now you had the chance to cross-examine him on the number, and you didn't. So therefore, it's basically, I don't want to say stipulated to, but unimpeached.
Well, he can say any number he wants. And that number is from his claims and contentions in the stipulation for settlement. That's an exhibit. Just like in our claims and contentions, we indicated there was no injury. It doesn't make it correct. It doesn't make it accurate. He's making an argument. He's claiming a number. But there still has to be evidence to support the number. And in this case, there's just no evidence to support the number. And again, based on the errors in our briefs, I wouldn't be really confident in accepting the number, but that's me.
What about the rule that Judge Pearson relies upon that, again, I'm going to paraphrase, but everything that's in the OAH or CAH file is everything, and I can rely upon anything that's there as a compensation judge?
Well, I think that is what subpart 14, you're talking about 14202900, subpart 7B1.
Yep.
Which is all pleadings, motions, and orders.
Yep.
But first, again, that pleading was dismissed as if it was never filed. But then I think one also has to look at 7B2, which talks about Rule 14153500, which is evidence received or considered. And when one looks at 14153500, it says, for purposes of this part, an exhibit is a document or other evidence that is introduced at a hearing and is marked. And in this case, the bills weren't introduced as an exhibit, and they were never marked. If the court will indulge me for a minute, let's assume we didn't settle this case. As part of the original claim petition, that is an exhibit, Mr. Bjornson claimed entitlement to temporary total disability benefits. Let's assume that we objected and we did surveillance, and it shows Mr. Bjornson engaging in all sorts of activities beyond his claimed abilities. I serve and file the surveillance in C-Track as part of a discovery response, but I don't introduce it at the hearing. Would it be appropriate for a compensation judge to comb through everything that's been filed, including attachments to a discovery response, and rely on that as evidence to deny a claim?
Well, that's what's happening here, isn't that correct, Mr. Klayman?
That is what's happening here, and I would argue nobody would tolerate that.
Well, if you look at that rule, again, 1420.2900, subpart 7, and this is where I know that the judge states, and of course this is what the rule states, the record shall contain all pleadings, motions, and orders. And as part of the pleadings, the claim petition attached to that were all of these bills. But it goes on to say, under 3, that's subdivision 7B3, would include those parts of the division's official file
Well,
on the matter which the judge incorporates on the record. So would it have been necessary, if the judge were going to include the attachments to that claim petition, that she made mention of that on the record
well, I think
at that trial?
I think she does need to formally incorporate the claim petition and its attachments on the record, and she doesn't do that. One can read the entire trial transcript. She does not incorporate that claim petition and attachments into the record. And she can't, because as indicated earlier, it was dismissed, so it was like it was never filed. That claim petition doesn't exist.
Mr. Clement, isn't there also a statute that tells us exactly what the judge must base his or her decision upon?
There is, Your Honor, and I'm also glad you asked that. Let me get to that page of my brief, sorry. Minnesota Statute 176.411, Subdivision 1, provides that findings of fact shall be based upon relevant and material evidence only, and 176.021, Subdivision 1A, defines a preponderance of the evidence as evidence produced in substantiation of a fact. Now here, that evidence was not produced in substantiation of a fact. It does not exist. Now, Judge Pearson can rely on 1429.2900 and talk about the official CAH record, and that still seems so weird for me to say CAH, but that doesn't mean that anything in the CAH file is evidence in the record. We don't want to conflate those two ideas. There are rules that govern what is and is not evidence. And just because something's in the official CAH record does not mean it's in the official hearing record. I think that there's simply no evidence in the record to support that Mr. Wolf recovered an ascertainable specific amount of medical bills on behalf of his client. And therefore, again, this court should affirm its decision in its entirety. And I reserve my extra time. Thank you.
Thank you, Mr. Clement. Mr. Wolf, when you are ready.
I am always ready.
Fair enough.
May it please the court. David Wolf, I represent the employee in this matter, Rodney Bjornson, but this appeal relates to my claim for fees. So I'm the claimant. This court vacated Judge Pearson's finding and order in its first decision because the itemized bills from the Mayo Clinic Health System were not successfully introduced and accepted into evidence at the attorney fee hearing. The Minnesota Supreme Court found that decision and that reasoning to be reversible error and reversed this court's decision. Therefore, the Supreme Court has conclusively established that Judge Pearson's finding and order cannot be reversed, vacated, or otherwise modified just because the itemized bills were not accepted into evidence at the attorney fee hearing. The Supreme Court remanded this case to this court with two very specific and limited instructions. First, the Supreme Court recognized that Judge Pearson indicated in her findings and order that she had reviewed and considered the itemized bills from the Mayo Clinic. Judge Pearson could only have done that if she took the initiative to review the claim petition that I originally filed to initiate the claim, which included as an attached exhibit all of the itemized bills from the Mayo Clinic. The Supreme Court instructed this court to ask Judge Pearson to clarify whether she had in fact reviewed the itemized bills or if she was referring to the detailed itemization of benefits that I had prepared and did successfully introduce into evidence as Exhibit G. Notably, the Supreme Court did not indicate that if Judge Pearson had reviewed the claim petition on file in the record at OAHCH, that would be somehow impermissible. If they believed that Judge Pearson reviewing the claim petition was impermissible, they would have said so. And they would not have instructed this court to ask Judge Pearson to confirm whether that is what she did, because what would be the point? Also notably, the Supreme Court did not instruct this court to consider any type of argument concerning whether it was permissible for Judge Pearson to review the claim petition and the bills attached thereto. If the Supreme Court wanted this court to consider such an argument, it would have said so in its decision. They didn't.
All right, Mr. Wolf, I'm going to interrupt you. Questions?
Yes, Mr. Wolf, I'm looking at the Supreme Court decision right now, and the wording is, second part of the two things that the Supreme Court has asked this court to do, is the second one is after the clarification from the compensation judge, the WCCA must review the evidence in the record to determine whether a reasonable mind might accept that evidence. For example, Wolf's testimony and supporting exhibits, including the summary document, as adequate to support the compensation judge's conclusion. So are you saying that our hands are tied? Or are you saying that we are obviously, we're allowed to make a decision, we're able to look at what the judge did here on remand and draw our own conclusions?
No, and if I could read faster, I would have gotten through the entire argument in 3 minutes, but no. So what the Supreme Court did is they remanded to you saying, clarify with Judge Pearson what she actually reviewed. Did she look at the actual bills or did she look at the summary? Once you get the answer to that question, that will tell you whether the bills themselves were considered by Judge Pearson and it would constitute part of the evidence upon which she based her decision. That would then add to all of the testimony and all of the exhibits that you have to review to determine whether her decision is clearly erroneous and unsupported by any substantial evidence in the record when viewed as a whole that a reasonable mind might consider reasonable or might find adequate. So
Wolf,
what is the record?
Mr. Wolf, I have a hypothetical I'd like to ask you. I'm just going to assume, I want you to assume this. Let's say Mr. Klayman had, in another case, one involving a medical issue, for example, a medical issue on causation. Mr. Klayman had filed an answer, and in the answer he had attached a copy of his medical expert's opinion. You go to trial, Mr. Klayman does not introduce that exhibit or that opinion as an exhibit. The judge looks at that anyway, relies on it, and then issues a decision stating that the IME opinion, the medical expert opinion that Mr. Klayman had attached to his answer is adopted, and I'm going with that. Would you have grounds to appeal that case? And what do you think the outcome should be?
Confront the same argument. The record, what is the record? That's one of the issues here.
So you're saying that that would be a part of the record?
That would be a part of the record according to the rule. Now, Minnesota Rule 1420.2900, subpart 7, defines what constitutes the record.
But what about Mr. Klayman's argument? The original claim petition has been dismissed. There was a settlement, claim petition dismissed. You file a new document, petition for attorney fees, creating an entire new case. That claim petition and all of its attachments from the old thing that's been dismissed. It's not part of.
It still exists in the record.
The record of what?
The OAH record. The claim petition is in the record as defined by the rule in the C-track file.
All right.
So
But
for the
Mr.
purposes of it being pursued as a claim, it's dismissed, it's gone because it's been settled.
Right.
But for the purposes of my getting paid for negotiating the settlement, the claim petition is still in the record and can still be considered by the judge.
But
So
what,
if there's-
Mr.
oh,
Klayman,
go ahead.
or Mr. Wolf, if what was attached in the record, a part of the record, but wasn't actually evidence, was considered inadmissible evidence at some point, would that be part of the record? If it were evidence or potentially evidence that was inadmissible?
That isn't this case, but Probably not.
And so that begs the question. How does a litigant, how does an attorney know when they walk into a courtroom that I need to object to stuff that my opponent is not offering into evidence that might be in that file? How do you know to do that?
Because the rule says that the record includes the pleadings. That would be the simple answer. But also, I don't want to waste too much more time on this point because the Supreme Court has indicated that you have to look at all of the evidence that I presented at the attorney fee hearing. So let's accept, for the sake of argument, that it was impermissible for the judge to consider the claim petition, even though it was part of the record and the attachments there too. Let's accept, for the sake of argument, that the itemized bills were never considered by Judge Pearson, even though she said she did. She confirmed that she did. You still have to look at everything else. My testimony. Okay, my testimony in and of itself is sufficient.
Within
to
that
support the
testimony, did you
findings of
put
order.
in the fee schedule, the amount of the bills?
The fee schedule doesn't matter, Judge.
Why?
The attorney's fees are based upon what is paid, not the fee schedule.
Do we know what was paid?
Yes, I testified, $327,000,
How do you know it was paid?
because the medical bill said that and counsel didn't dispute that.
And see,
That was never raised as a disputed fact.
all right, so there's bills somewhere. There's also the itemization of what United Healthcare paid, correct?
Right, which are in the bills.
Okay, it's in the bills. All right, and then Irwin, and you know Irwin probably better than anyone in this room, Irwin says the 20% number for a RF fee is to be applied to the amount of the recovery.
Right, the amount paid.
All right, well, the amount of the recovery. All right,
Right.
so what did you recover for your client? So I'm looking at the STIP, and the STIP says, the employer and Hartford do not dispute the treatment, blah, 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 is related, and agree to defend and indemnify and save and hold him harmless with regards to any claims for any spathe balance that may be owed.
And
Is
in your
that what
first-
you is that what you recovered?
That's what you decided in your first decision here.
Okay. Is
In the
that what you
first
recovered?
decision, you decided that I recovered the medical expense benefits in the amount that was paid by United Healthcare. The issue becoming, what is the ascertainable dollar value of the amount that was paid? That decision was an appeal to the Supreme Court. That has become the law of this case. So we're not going to rehash that again. It's really, is there sufficient evidence to support the finding that the ascertainable dollar value of the amount paid that I recovered by convincing them to admit that this is a work-related injury and that all of the treatment was reasonably required to cure or relieve the effects of that injury?
Mr. Wolf, did you admit or get any evidence admitted that stated that the employer actually paid?
I'm sorry, I didn't hear you.
That the
your voice.
employer, I'm sorry, that the employer actually paid those medical bills?
Yeah, that was never disputed. That in fact was the argument why I shouldn't be paid a RORAT fee.
No, where did it say that the employer had actually paid?
In the
medical
stipulation,
bills.
which was not disputed, it was drafted by Mr. Klayman and not disputed.
I didn't see that in the stipulation. Can you tell me where that was?
Look in the paragraph where I lay out my claims. Look at my client's claims.
Are you talking about your claims and contentions part in this stipulation?
Yeah.
So there was no
Which he didn't
agreement.
dispute. And he also didn't dispute it at the attorney fee hearing. His whole argument was his client paid 100% of the charges from the Mayo Clinic as health plan benefits, and therefore I didn't recover medical expense benefits as workers' comp benefits
Right,
because
that
they've
was
been
one of
paid
his
voluntarily
defenses.
and all that.
And that has been rejected by the trial judge and this court.
Yeah,
Agreed.
and it wasn't appealed. So that's an established fact that was never disputed.
But one of
That
his,
they paid 100% of the bills and they paid an amount in excess of $327,000.
reading through the transcript, Mr. Wolf, it was my understanding that Mr. Klayman argued over and over again that there's no proof that his client paid medical bills. None. And would that be your burden to show that the
Which
employer
I
had
did
actually
show,
paid?
Judge Pearson found that. I mean, I won at the attorney fee hearing. He has the burden of proving that that was clearly erroneous and unsupported by any substantial evidence in the record when viewed as a whole, which the Supreme Court has clarified includes my testimony. They said, take a look at Wolf's testimony. They said, take a look at the summary that he prepared. Take a look at the other 12 exhibits. And if Judge Pearson confirms that she reviewed the bills, take a look at the bills. That's what the Supreme Court has instructed this court to do.
All right, so if we acknowledge that the employer, not as a work comp insurer, but as a health insurer, paid the $327,000 whatever to the penny dollars, that's the amount recovered. That's your argument.
Yeah, that's
Okay.
what the judge found. That's what the Supreme Court has instructed you to determine if there's adequate evidence to support that.
Okay.
My testimony, the summary, all 12 of my exhibits, even ignoring the itemized bills from the Mayo Clinic, there's certainly sufficient evidence, especially there's no evidence to the contrary. No exhibits were introduced by opposing counsel, and he never testified to a different number. His client paid. His client knows exactly how much they paid. If the number was different, he could have very easily produced the evidence to show that it was a different amount. He didn't. He didn't dispute my number, my math.
What about this last issue where we have Judge Pearson sending us a document saying, here's what I looked at. We made our decision. Supreme Court made their decision. We remanded back. Then she sends new findings in order and says, here's the documents I looked at, and all of a sudden your claim petition is in there, where it wasn't there in the first time and there was no new evidence admitted. You know, and importantly, she didn't list everything in the record, whatever the record is. She just added one more document, your claim petition with all of the attachments. That looks, I don't know what the right word is. Not right.
It would have been nice if she had been clear from the beginning, I agree. But I shouldn't be penalized that she wasn't. You know, it wasn't my fault. And my fees are.
Well, in the sense that you didn't offer it as exhibit at the hearing.
I didn't successfully upload it into C-Track,
Yeah.
that's correct.
Okay. All right, because the other thing that troubles me, and it's not your fault, and it's not Mr. Klayman's fault, and frankly, it's not Judge Pearson's fault either, is we have different filing systems for different court systems.
Right.
And, you know, we don't have access to C-Track, we have access to campus. And that creates a whole different level of issues. And that's why what is the record is so important.
But don't forget that the Minnesota Supreme Court found it to be reversible error for this court to vacate Judge Pearson's finding based upon the lack of the itemized bills. So that's, you know, that's kind of a moot issue at this point.
Any other questions?
Yeah, I do have one more question. Yes, Mr. Wolf, I'd like you to, I'd like to know if you're familiar with MnSTAT section 176.411, which is the rules of evidence section for workers' compensation. And that statute specifically says that findings of fact, which the judge did here, shall, there's no movement or no room for movement there, it shall, it's a mandate. Findings of fact shall be based on relevant and material evidence only. That statute says only, it doesn't say anything about the record.
Well, it says that the judge may consider any document in the record of this case when viewed as a whole that she believed was relevant and material in carrying out her obligation to ascertain the substantial rights of the parties.
And that's what the Supreme Court said.
Right.
But that's not what the statute says. So I'm wondering if there's some
I like the Supreme
inconsistency.
Court.
I'm wondering if there's some inconsistency with what the Supreme Court said versus what the statute says.
Well, I think the Supreme Court gets to interpret the statutes, and I think that their decision controls. I think that there's some confusion between evidence accepted into evidence at a hearing versus the record when viewed as a whole. And the standard of review that this court is obligated to apply and adhere to is a determination of whether there's any substantial evidence in the record when viewed as a whole, which is defined by 1420.2900 subpart 7 to include not only the exhibits and testimony accepted into evidence at the hearing, but also the pleadings, which is what Judge Pearson took the initiative to review to determine the truth and to base her decision upon a correct understanding of the amount paid by the employer. So I think there's, I think there's a difference in terminology, which is a little bit confusing.
All right, thank you, Mr. Wolf.
Thank you.
How far did we go over? Okay. Mr. Klayman, you've got 3+ minutes of rebuttal time.
Thank you, Your Honors. I'd like to address a few things that Mr. Wolf said. First, I think he's mischaracterizing the charge the Minnesota Supreme Court gave to this court and this court gave to Judge Pearson. On remand, the issue wasn't, what did Judge Pearson review? That wasn't the question that this court was told to ask Judge Pearson. This court was told to ask Judge Pearson, were the bills attached, or was it just a summary of the bills? The answer is no. It's somewhat irrelevant what Judge Pearson is now saying she reviewed. That wasn't the question before her. Once she answered that question, this court was to determine whether there was substantial evidence to support Judge Pearson's award of attorney's fees. It's clear there's not. Mr. Wolf claims I never objected to his argument that my clients paid $327,000 in medical bills. As Judge Sundquist noted, I did so repeatedly throughout the hearing before Judge Pearson. I have no idea what United Healthcare paid. No one knows what United Healthcare paid. And again, under Irwin, it's got to be paid pursuant to the fee schedule. There's no evidence of that. And that's the relevant issue. This court found that Mr. Wolf obtained a recovery for his clients when we agreed to hold Mr. Bjornson harmless from the medical bills. But it also found there's no evidence of an ascertainable amount. So it was, you awarded $500. We didn't appeal that because, frankly, it is a recovery for us to hold Mr. Bjornson harmless. But again, we have no idea what was paid. We know the employers and insurers in the workers' compensation system paid $0. Thank you.
Thank you, Mr. Klayman. All right, thank you both for your presentations. The record is now closed, and this court will issue a decision within 90 days. Normally, we would now say court is adjourned and we'd leave, but we're going to stick around for question and answers. And both of the attorneys have graciously agreed to stick around. The only topic that is off limits is today's case. You cannot ask any of us questions about that. And if you do, we're not going to answer any questions. So, with that said, what would you young people like to know?
Can I sit behind the desk so I don't have to?
I don't care. Oh, come on now. There's at least 5 people on the back that better have questions. Oh, way in the back.
Hello. I'd like to ask, how often... I'd like to ask, as a proportion of your caseload, how often are you dealing with direct continuations of the original dispute over compensation versus cases more like today's where it's a something arising out of the process of the suit rather than or proceeding rather than the original injury at work?
I didn't understand the question.
I think I did. how often do we deal with cases that are substantively about the injury claim and defenses versus sort of ancillary claims like attorney fees or whatever that come out of it? Is that fair?
Absolutely.
Okay.
Thank you.
Deb?
I don't really know what to say.
Yeah.
I'm not quite sure.
I think, personally, I think it's more like 80-90% are more about the claims of the injured employee or the defenses of the employer and the insurer versus claims like attorney fees. Although there was a stretch where we were going through a lot more attorney fee disputes, less so nowadays.
And as a practicing attorney representing injured workers, 100% of my cases involve claims of my client, and probably 100% of the cases involve claims for my fees. So I get involved in attorney fee claims a lot. Probably, well, I do settle some of those. But in my experience as a practicing attorney, these so-called ancillary claims for attorney's fees and costs come up in pretty much every case. They don't always go to the Workers' Comp Court of Appeals, thankfully.
Yes.
I frequently end up having to try my entitlement to fees to the compensation.
As a practicing attorney on my side, I would say 95% of fee claims are a part of an overall claim, and those claims settle with the overall claim.
I'm staring back there. You can't think of any. So the 5 people in the way back are my students because I teach work comp here. And all of you who are second years or first years in the room better be taking work comp next fall because I'm looking at all of you.
I would second that. This has been probably one of my favorite classes throughout law school. And I'm not saying that because Professor Quinn is staring at me right now as I'm talking. But my name is my name is Fide. I guess the question that I have is, like longevity and well-being in the legal space is a rising topic these days. So how would you say that workers' compensation in particular allows you to have a good work-life balance while creating a meaningful career?
I can actually answer that because I practiced law for a number of years, 26 years, and I'm a mother of 4 children, and I would say workers' compensation was one of the best places to be as a working mother. The bar is extremely friendly. It's a tight-knit group of people. We all pretty much know each other fairly well. I know both of these gentlemen very well. I've had cases against them or with them, and I actually at one point practiced with Mr. Claimant. Why did I not recuse myself in this case? Because I've been with the court for a long, long time now, and I don't have any sort of financial attachment to that former law firm. I've also known Mr. Wolf for a long, long time, and Mr. Wolf has had an incredible career in arguing before appellate courts on attorney fees. He's a remarkably successful lawyer. So I have incredible respect for both of these gentlemen, and that's partly because we are a close-knit bar. We get along. Even with the judges that decide cases on the lower level of our judicial process, our court, and then the attorneys who practice in the bar, it's just congenial. It's a very nice place to be. So I would highly encourage you to consider it.
I will add to that. I hate comparing a working father to a working mother because that is patently unfair. With that said, I missed 0% of my children's school plays, concerts, baseball games, soccer games, etc. In fact, I coached their soccer teams, both teams, for years together, and it was a large part because practicing workers' comp allowed me to do that. Did I work nights and weekends at times? Of course I did. But every area of law, you're going to do that anyway. But you can rearrange your schedule and manage your schedule very effectively in the work comp arena. Whether that's true in other areas of law, I can't say for sure.
Hello. I am also a workers' comp student. This is a question that we've talked about a lot in class, but I'd like to get more perspectives on it. As practitioners and jurists in a field that's fairly specialized doctrinally, how do you structure your arguments, your briefs, the opinions that you write, with the knowledge that there is a possibility of appeal to a non-specialized court like the Supreme Court of Minnesota?
That's an outstanding question.
That's your favorite.
Yeah, I will note that you didn't praise my class, so point down, but that's okay.
You have a nice tie.
You guys, he wants different perspectives, he doesn't want mine.
I think that the justices at the Minnesota Supreme Court are experts in many areas of law and have the legal ability and intellect to read and analyze and decide a workers' compensation case. Not to say that workers' compensation is simple, but if the parties do a nice job of spelling out the issues and the law, the justices and their clerks can decide the issues usually correctly.
Is this being recorded?
I don't know if this part is.
The Minnesota Supreme Court certainly is very competent and very capable. I think that it can be argued that workers' compensation law is not one of their specialties necessarily. But like in any type of law, as a practicing attorney, you have to be thinking about appeals all the way up to the Supreme Court from the very beginning of any case. So you have to structure your claims and the evidence and the testimony that you're going to marshal and be thinking about, okay, at the hearing, what do I have to put into evidence? What do I have to argue to the trial judge in the event that the decision either goes against my client or for the client, but it gets appealed? And what do I have to put into the basic trial so that on the appeal I can successfully argue the legal issues that are going to be determined based upon the evidence that I put in? So I think in any type of law that you practice, you always, if your practice involves any kind of litigation at all, any type of trial, you always have to be aware of and thinking about, what if this goes up on appeal? Have I put in all of the correct pieces of evidence? Did I elicit all of the right testimony? Have I put in the right documentary evidence? Have I made the right legal arguments? Have I reserved issues for appeal? And that can deal with evidentiary rulings. So you have to be putting in the foundation for the evidence that you want to put in. Being aware of the fact that the judge might exclude the evidence that you want to put in. And so you have to preserve your right to be able to appeal that exclusion and possibly get that reversed. But I think in workers' comp, just like any type of litigation, you always have to be thinking ahead and getting your ducks in a row.
I will note that Justice Thiessen once said at a CLE that I attended that Judge Carlson moderated that he knows he doesn't know anything about workers' comp or knows very little about workers' comp, and that we should, practitioners should write their briefs and present their oral arguments as if he was a kindergartner, as it were. And I think those are his words. Is that what he's?
Yeah, those were his words. He said, take a few extra pages and explain things to me from the beginning. We use a lot of acronyms, kind of our shorthand, the language that we develop that they're not familiar with. If we use the word rehabilitation, we know we mean vocational rehabilitation. They think we mean physical, they think it's a medical benefit. So it's just taking a step back and explaining it from the beginning.
Oh, there we go.
Hi, I'm Claire. I'm also in workers' comp, which I love so much. You should all take.
Oh, just as we practiced, excellent.
Yeah, I've been rehearsing. So my question, we've talked about this in class a little bit, but I think it's really interesting. It's something that other people might not be familiar with. But I was wondering if the judges could talk a little about how you prepare for cases, like whether you meet before or after, and how that might compare to other kind of panel courts, and if your approach changes for a case like this, where you're not just seeing it for the first time, but seeing it after it's been to the Supreme Court or back down and then back to you.
Well, I kind of cheat on cases. Basically, we know like 3 or 4 months ahead of time, a notice of appeal comes in. Once that notice of appeal comes in, we get the findings in order from the judge at the Court of Administrative Hearings. Once that's there, the exhibits come in. I like to read those things way before I ever see it. I think Judge Carlson does the same thing, just to know what's coming and seeing what's there. Once it's in the office, one of the staff attorneys is assigned, kind of marshals the various things, does a voting memo for us that we then vote on whether or not we're going to have oral argument or not, whether it's a 3-panel or 5-panel, and whether we have any conflicts. Once that happens, then it's assigned, and then we set it for oral argument or not oral argument. But along the period of time, if it is oral argument, like on this case, we had met before, and I don't know how many times we met prior to today's oral argument to review the facts and the evidence and the briefs, and we go over things quite thoroughly before we even come here today, and then right before we do the same things, and we will meet afterwards, not this afternoon likely, but probably tomorrow morning to discuss the case and we'll review the oral argument and what will happen from there. But that's what we do. We've had conversations with the Supreme Court and the justices there, and oftentimes they get their bench memos or voting memos. They oftentimes don't talk about the case itself until after the oral argument, and then they have a different process of reviewing the case with the Chief Justice being the last person to decide, and then they choose who's going to write it and go from there. We have 90 days to get a decision out. The Supreme Court, they have as much time as they want. They could take this case and it could be a year or it could be 2 months or anything in between, where we have a set pattern. And when we talk about the Court of Administrative Hearings, when it's at that initial level, they have 60 days. And unlike our court, where we have a panel of 3 or 5, we have 4 wonderful staff attorneys and a staff that supports us. I was talking to one of the top judges last week, and they have 30 judges both on the administrative law side and on the work comp side. They have 4 staff attorneys for 30. So they have a much more difficult time and harder job than we do. One, we have time, we have each other, and we have a wonderful staff attorney. And just like the bench that, or the bar that comes before us, we are very collegial, respectful, cooperative amongst ourselves, and our whole goal always, and let them, we always try to make sure it's, whatever we do is right and understandable and goes out so the bar knows where we are, and the judges at the office or the Court of, I say it too, David, Court of Administrative Hearings. It's going to be difficult to get used to that saying, but just to make sure it's right and understandable.
That's pretty comprehensive.
I would say, as far as the collaborativeness of our panel situation or panel courts, I find it fascinating. I will, get a case. I'll read the things that I need to read. I'll kind of make a preliminary decision in my head. We'll meet ahead of time. Somebody will say something, one of my fellow judges will say something that causes me to go, oh, well, maybe I'm looking at this wrong, and I'll take another look at it. Then we have oral argument. The attorneys might change my mind. Then we have post-argument discussion. Change my mind again, or shift a little bit. So I try to keep a very open mind about every case. There was a decision that came out of our court, I think it was earlier this year, and it was 5 of us. And at the end of oral argument, it was 4 one way, 1 dissent. I was the dissent. I wrote out the dissent. 2 of the judges in the majority said, oh, I like that. They came onto my side. So then it was 3-2 the other way. I talked with who was going to be the presumptive author of the 4-1 side, and she convinced me that she was right, and I switched back, and the 2 that liked my dissent went with my dissent, and they rewrote it in the way they wanted it, and I went back with the majority, and it all worked out well because both decisions were really well written, and they kind of complemented each other, as it were. And that is the wonderful thing about a panel court that trial judges don't necessarily get to have. Any Section E people in the House? Yay. Judge Carlson is a Section E-er. So am I. Anyone interested in externships? Judge Carlson is also in charge of our externship program. Not that I'm promising anything, but every extern from this law school to our court has received a judicial clerkship offer, correct?
Yes.
Just saying, including one sitting in the room right now.
Very prestigious.
Yeah, so not saying that you're guaranteed a judicial clerkship if you extern at our court, but pretty much. Yeah. Any other questions?
Yep.
Hello, my name is Dylan. I am also in the work comp class, and I just have to say it is amazing, right, Judge Quinn?
They all know their lines so well.
We do. We rehearsed. I had a question about liberal construction. So some other courts around the United States have liberal construction when it comes to work comp. Minnesota does not have liberal construction. Do you see liberal construction on the rise, or do you see more and more states start to adopt what Minnesota has adopted?
Well, first I want to say what an honor it was to appear before all of you and this esteemed panel.
Go ahead, Dave.
So back in the day, I think it was in the 70s, Minnesota used to have liberal construction. And they switched to take away liberal construction of the Work Comp Act. And I don't see Minnesota going back, and frankly, I can't talk about what other states are going to do. But based on, I have clients that deal with other states, and I don't see a lot of them awarding more benefits than Minnesota necessarily does, so it's irrelevant if they have liberal construction.
Anyone else you practiced outside of Minnesota?
Yeah, it's basically even-handed. I mean, North Dakota has a state-run system, and so if you never represent the employer and the state, that's all done by Assistant Attorney General. So you represent an injured worker, which I did one time, but in that system, all I can tell you is we had the hearing. There's a period of time for a decision to come out. I got a call from the Assistant Attorney General and said, here's the best deal you're ever going to get, and set out the deal. And he said, otherwise you're going to lose, because the hearing officer was not an attorney. The Assistant Attorney General was going to write the decision in which I was going to lose, talk to my client, we accepted the offer, but basically after that I decided that probably isn't something I wanted to do again, so I did not. So I don't think North Dakota has liberal construction.
Certainly don't have liberal laws. Any other questions? All right. Thank you all for coming here and watching us. Thanks again to both lawyers. Thanks to our staff, too.
Yep.
Our wonderful staff here and there. So, all right. You're adjourned.